In persuading judges, credibility is very important. You get that credibility by being the reliable lawyer that the judge can rely on in terms of knowing the facts and knowing the law applicable to the case. The most important part of that is preparation, because if you're not prepared, the judge is going to notice that right away. One of the reasons you want to give the judge the correct law and the facts is so the judge has a framework first, the law in other words, in which to view the decision, but then the facts fill in that frame and gives the judge the reason to decide in favor of your client. Judges are generalists. We don't have the option of saying that we don't handle certain types of cases. As soon as the clerk assigns a case to us, that's what we have to decide. And if lawyers understand that, they can help the judge come to the conclusion their client wants. Because judges are looking for help. They can't know everything about every area of the law. And if an attorney can come in and say, Judge, here's the substantive law in this area, here are the procedures to use, here are the facts in this case that fit into those procedures and substance, they will have great credibility with the judge. And then at the step in the process where the attorney wants to try to convince the judge why their client is right, they will have the judge's attention because they've already given the judge the correct substance of the law, the correct procedures, and the facts needed to make that decision. Persuading a jury is somewhat different than persuading a judge. There are really two parts of persuading juries. The first is to have an overarching theme for the jurors to see the case through. We have, as attorneys, a construct to understand something. As an example, in a tort case, we understand that it's duty, breach of duty, cause, and damages. The jury doesn't have that coming in, and if you can explain the case, not in legal terms necessarily, but in factual terms of why your client did something, the judge will then have empathy with your client and understand the framework that you want to put the question in. The second part is you have to have the facts to fill in that framework. If you don't have both, you're not going to do well with the jury. But give the framework and then show the jury the facts that they can put into that. That will allow them to connect the dots in the way you want them to connect it. You can have the best taglines or best themes in the world, and if you don't have the facts, you're going to have problems with a jury. Attorneys can approach judges to get their feedback from the judges about how they've been doing things, if they can do it better, what's working well, what's not working quite so well. Of course, one wouldn't want to do that during a trial with the judge right then, or even maybe a few days after a trial, but let things cool off, so to speak, and come back months later and ask judges. I think, the judge doesn't have to talk to the attorney about it. I think most judges are very receptive to that because they want to see good advocacy in their courtroom, and they have suggestions, probably for a young lawyer especially in that regard.